Thanks, Judd, and thanks to Michael McConnell for putting together this really stellar conference. So the next panel will really flow from the previous one, and particularly the remarks of Peter Strauss in the last panel about this fundamental and unsolvable problem of delegation. So we know that Congress is supposed to make the laws and the executive only to carry them out, but it's never worked out that way. And from the first Congress onward, Congress always has delegated rulemaking power to the executive. And we've come to accept that, but we limit it by some sort of intelligible standard approach, because Congress is supposed to make the big decisions and only the little decisions are to be made by the executive. But, you know, it's never worked out that way either. And I think everyone recognizes that Congress is going to and always will pass on the tough calls to the executive. This has created a problem in administrative law of legitimacy there's never been adequately solved. And this panel will continue with different approaches to that problem. And I hope they'll talk about what Peter said was the ameliorative approach. We can't really solve this one. We know Congress isn't going to make the big calls. They never will. But how can we somehow fill in this gap? So we have a great panel. Our first speaker, Mila Sohoni, she's an assistant professor of law at the University of San Diego School of Law. She clerked for Judge Rogers at the D.C. Circuit, practiced law, and has really written a string of tremendous articles in top publications since she went into teaching about various aspects of separation of powers. Our second speaker will be Srisha Prakash. He's a professor at University of Virginia School of Law, focusing on areas of separation of powers. He clerked for Judge Silberman of the D.C. Circuit and for Justice Clarence Thomas, and again has a string of really interesting publications on questions of separation of powers. Our third speaker will be Don Elliott, Yale Law School, who really needs no introduction. He's such a fixture of environmental and administrative law in this country. Don's a professor at Yale, as well as practicing lawyer at Covington and Burling, and he served as the assistant administrator and general counsel of EPA from '89 to '91. And our fourth speaker will be Michael Greve. Michael's a professor at George Mason University, and prior to that was the Searle Scholar at the American Enterprise Institute. And he, again, has written on many aspects of the American legal system, including constitutional law and separation of powers. So, Mila, take it away.
Thank you, Mike. And thank you to Mike McConnell and Judd for organizing this event, and Dean McGill and Stanford Law School for being such generous hosts. So the primary theme of this conference has been the relationship between the Constitution and the administrative state. But the particular motif within that theme that keeps popping up is the motif of how delegation can be made compatible with the rule of law. To many, the tension between delegation and the rule of law has seemed particularly acute recently. Programs for the issuance of waivers in immigration, in education, and in healthcare are having important effects on millions of individuals and entities in a vast array of circumstances. But waiver is only part of that story. Domestic policy is also being altered and implemented through informal guidance issued by federal agencies like the Department of Education, through deal-making by Treasury and by FIFA, and through out-of-court settlements and consent decrees by the Department of Justice and the SEC. Waiver, deal-making, settlement, guidance, these forms of administrative power are all of a piece. They are distinctively or particularly executive forms of law creation in the sense that they are techniques for achieving policy goals through shaping implementation, enforcement, and enforcement prioritization. Moreover, they are techniques over which the executive branch enjoys dominant and sometimes even exclusive control. Many, including several folks here, such as Zach Price, have written about the constitutional problems with some of these executive branch actions. My focus, though, is on the administrative law values that they implicate, on administrative law values as separate from and supplemental to constitutional law values. Today, I would like to focus my remarks on these administrative law values and discuss why the erosion of administrative procedural constraints is a distinctive and significant feature of the current legal landscape. Let me illustrate what I'm talking about with the executive branch's use of waiver. For decades, agencies had used waiver policies to effectively exempt individuals and entities from otherwise applicable statutory schemes. A couple of recent and newsworthy examples were the delay of the ACA's employer mandate, and in the immigration context, the deferred action waiver programs that Peter Shane spoke about yesterday, and I'll just call them DACA and DAPA. In none of these cases of waiver did the agencies issuing these waivers follow ordinary administrative law procedures that apply to rulemaking. By that I mean that the relevant agencies did not issue a contemporaneous justification for why a waiver policy was necessary. They did not issue a proposed waiver for comment in advance of its adoption, and they didn't respond to input from the public or from affected parties before finalizing the waiver policy. Why didn't these agencies in issuing waivers go through the usual procedural moves that generally accompany agency action? Well, one very simple reason that they didn't do these moves is that they did not have to. The rules of administrative procedure include lots of outs. The APA contains an exception to notice and comment rulemaking where procedures would be impracticable, unnecessary, or contrary to the public interest, as well as an exception for interpretive rules and for policy statements. Agencies enjoy tremendous discretion in exercising enforcement discretion, and their exercise of enforcement discretion is non-reviewable often. Rules of standing and the requirement of final agency action insulate certain kinds of agency conduct from judicial review, and Congress may preclude judicial review of agency action. Finally, Vermont Yankee, and now Perez v. Mortgage Bankers, stand for the proposition that agencies and not courts bear the ultimate responsibility for shaping their own procedures. If you take all of these propositions together, you will see why it is that agency action in issuing waivers falls into a procedural dead zone, a zone in which agencies may act without advance notice, without public and contemporaneous reason giving, and in some cases without a reasonable prospect of meaningful judicial review on the merits. To put it another way, the rules of administrative procedure, as currently constructed, do not form a wall or a barrier or a filter through which all executive action must pass. Rather, administrative procedure is like a padlock with a complicated combination. Just like a padlock, administrative procedure is a sturdy checkpoint that is hard to bypass unless you happen to know the right combination of moves. Today, the executive branch is more and more often using that combination to bypass the check of fundamental administrative procedure. And as a result, the regulatory state is splitting into two parts: a regulatory state that is governed by the usual rule of administrative law, and a regulatory state that is governed by its exceptions. Alongside and in parallel to the administrative state, we see the emergence of something subtly but importantly different: an enforcement state, a regulatory state oriented towards empowering the executive branch to achieve critical domestic policy goals through enforcement and through enforcement prioritization, with little to no participation by the public or by the courts. Let me stress again that administrative law contemplates and authorizes these exemptions from administrative procedure and from judicial review. Administrative law itself creates the procedural dead zone. But the use of this dead zone, of such techniques, has traditionally been the exception and not the rule. If these techniques are not illegal, they are, however, relatively unusual. But now, what were formerly loopholes in or exceptions to administrative law, rarely invoked or invoked in narrow circumstances, appear to be acquiring a kind of sweep and a consequence that is comparable in scope to the sort of action governed by ordinary administrative law. This is a transformation, to be sure, and it is a very specific kind of transformation. It is a kind of transformation that involves not the violation of old norms, but instead a shift in emphasis towards a new normal, towards reliance on aspects of law that have always been there as a formal black letter matter, but that have traditionally been lightly used. We've seen this movie before, except that it was playing in a different theater. We saw it during the first great period of administrative state building, the New Deal era. Before the New Deal, the Commerce Clause, the Spending Clause, and the Supremacy Clause all existed. Formally, these clauses were part of the Constitution. They were written right there on the parchment, and they played a functional role as well. They were relied upon by Congress to carry out various federal schemes. But before the New Deal era, these clauses, individually and collectively, signified much less than they did after the New Deal era. The same phenomenon is now at work within the administrative state. Aspects of administrative law that enable procedurally unfettered regulation have a far larger footprint today than they used to have. Like the post-New Deal Commerce Clause, Spending Clause, and Supremacy Clause, these aspects of administrative law are now an order of magnitude more important than they once were. In short, what is happening to administrative law today looks quite a lot like what happened to constitutional law in the New Deal period. If all this sounds unlikely, then let me recount an anecdote that obliquely illustrates the parallels between what we are seeing today in administrative law and what we saw in the 1930s in constitutional law. As you all know, there have been only 2 cases in which the Supreme Court has struck down a federal statute as an unconstitutional delegation of power to the executive. One of them was Panama Refining Company, which addressed a section of the National Industrial Recovery Act and its petroleum code, which prohibited the transportation and commerce of oil produced or withdrawn in excess of state laws or regulations. The part of the petroleum code that limited oil production was subsequently rescinded by executive order. But, as the Supreme Court wrote, because of a failure to give appropriate public notice of the change in this section, this rescission was, for all intents and purposes, unknown even to the persons affected, the prosecuting authorities, and the courts. The case that had been litigated, the court wrote, on a false assumption. This discovery caused some consternation among the justices. Even Justice Cardozo, though he would have upheld the act's delegation of authority, wrote that one must deplore the administrative methods that brought uncertainty for a time as to the terms of executive orders intended to be law. So it's unimaginable that litigants today could litigate a case all the way to the Supreme Court without knowing whether or not the provision of law they were arguing over still existed. But in that era, as the country's experiment with NERA and industrial centralized planning unfolded, it was tough as a lawyer to keep up with the changing landscape of law. Today, the government's lawyers are again playing catch-up, as administrative methods, in Cardozo's phrase, have taken yet another new twist. November 2014, DHS issued revised guidelines for its DACA program and new guidelines for its DAPA program. Texas and several other states sued for a preliminary injunction to stop the implementation of DAPA and of revised DACA. The DOJ lawyers in that case informed the district court that DHS would start accepting requests for deferred action under the revised DACA and DAPA program in February 2015, and that the earliest decisions on deferred action would be made in March of this year. The district court timed its injunction of the case to those dates to ensure that its injunction wouldn't issue after the program had already started granting deferred actions. As it turned out, however, the Department of Justice had made a mistake. The revised DACA program wasn't about to begin, it had already begun. Between November 2014 and February 2015, USCIS had issued 3-year periods of deferred action to approximately 100,000 applicants under the authority of the November 2014 revised DACA order. There are striking parallels between the 2 stories. Then as now, we are seeing the emergence of new administrative methods that signal the onset of a new era in federal administration. Then as now, one hand doesn't quite know what the other hand is doing just yet. And then as now, the critical false assumption under which the case was being litigated pertained to the era's signature brand of delegated power. In that era, to the contents of the new petroleum code authorized by NERA, and in this era, to the exercise of the enforcement discretion authorized by the DHS memorandum. The echoes between these 2 anecdotes are striking, but it is hard to say how far the parallels will extend. In Panama Refining, the court drew a line on delegation that it was thereafter not willing to defend. It was left to Congress in the decade thereafter to come up with procedural rules that would constrain and legitimate the exercise of delegated power by the executive branch. It remains to be seen what analogous rules, if any, will be crafted for this, our new era of administrative law, an era not of the administrative state, but of the enforcement state. The core of the problem, as I see it, is that administrative law as currently constructed, administrative procedure as currently constructed, has little to no purchase on executive action with sweeping and broad-based effects. But administrative procedure has just as important a role to play in guiding and legitimizing these broad-scale regulatory actions as it does in guiding ordinary rulemaking. Whether denominated transition relief, waiver, deferred action, or for that matter, rule, broad-scale and consequential agency action ought to be implemented with advance notice, ought to be accompanied by contemporaneous reason-giving by the executive branch, and ought to give affected parties an opportunity to comment. To put it somewhat whimsically, it is time to ossify the ability of the executive to use these exceptions to administrative law. Time to ossify, and I'm going to bring it all together now, time to ossify its ability to use the combination to open the padlock to the procedural dead zone. That partial ossification would serve rule of law values and would also serve the broader public welfare. Consider again DACA and DAPA. Currently, that program has been carefully constructed to enable it to fit through the policy statement exception to notice and comment rulemaking. In particular, DHS argues the 2014 deferred action regime confers no benefits. The issuance of these waivers is subject to the discretion of individual immigration officers, and the deferred action waivers that ultimately issue are revocable at any time. Now consider this regime from the point of view of a person who wants to stay in the United States. What use is it to have a piece of paper that says you have received a 3-year deferred action waiver if you can't rely on that piece of paper? Conversely, is it fair to let some small handful of people be denied those pieces of paper when they meet all of the specified eligibility criteria because of an unreviewable discretionary choice by an immigration official, a choice made under a standard that, as the OLC notes, is left open-ended? This is not just a question of creating additional hoops for the executive branch to jump through. This is not just about adding more paperwork to make ourselves feel better. What is at stake here is how we are going to ensure that public administration and the enforcement state will occur in a fair and transparent and accountable way. I do recognize it's a sizable challenge, and even if, and it's a big if, we agree that adding more procedural constraints on the enforcement state would be a good idea, there still remains a subsequent question of who, if anyone, will be able to create those constraints. But at bottom, to my mind, what it all comes down to is the basic point of administrative procedure. If all men were good, there would be no need for criminal law. If all marriages were happy, there would be no need for family law. And if the delegation of lawmaking power were completely constitutional, there would be no need for administrative procedure. We have administrative law and procedure in order to address the original problem of delegation. And as the exercise of delegated power changes form, administrative procedure must change too.
Thank you. Sai?
Well, I want to thank Michael and Judd for inviting me to this wonderful conference. I've really enjoyed the panel so far, and I very much enjoyed being back at my alma mater. I also want to acknowledge a debt I owe to Professor Elliott. I was a student in 2 of his classes. I took admin from him, and then I liked it so much I took environmental law. Professor Elliott also was the professor who literally gave me my note topic. He said in class one day that presidential control of administrative discretion is a topic worth writing about, and I think he was right. And so in your own way too, Professor Elliott, you are responsible for me being here today.
Very proud of that.
Well, thank you, sir. I'm going to talk about 2 delegation-related topics in my very brief remarks. Professor Asimow asked us to be brief, and I'm going to be more than brief. First, what accounts for the differences between Justices Scalia and Thomas on non-delegation? That's my first topic. As many of you know, Scalia and Thomas are both originalists, looking to the original meaning of the Constitution as their guide. Yet, as I will discuss on the matter of delegation, they diverge in a dramatic way. Why are these allies at loggerheads? Second, given the features of conventional delegations of legislative authority, what other sorts of authority might Congress delegate? For instance, can Congress delegate the right to admit states or the right to overrule state laws related to federal elections? Moreover, may Congress delegate its power to propose amendments to some super expert body? Can Congress even delegate the power to amend the Constitution? It seems bizarre, but perhaps they may do so, at least if conventional delegations are constitutional, or so I will argue. So let me speak on the first topic, namely how and why do Justices Scalia and Thomas differ on non-delegation. In Mistretta, a case involving the constitutionality of the Sentencing Commission, Justice Scalia approvingly noted that the court, quote, has almost never felt qualified to second-guess Congress regarding the permissible degree of policy judgment that can be left to those executing or applying the law, unquote. Given other language in Scalia's Mistretta's dissent, one supposes that Scalia approves of this judicial forbearance because the non-delegation principle, he says, is ultimately a matter of degree. In other words, the Constitution implicitly establishes a standard rather than a rule, and as a vague standard, it is not susceptible to clean judicial enforcement. Because Justice Scalia mistrusts judicial enforcement of standards, he is unwilling to enforce the non-delegation principle, at least where the court has in the past evinced a consistent unwillingness to do so. The rule of law is a law of rules, not a law of standards. We see this strong preference for rules over standards play out in the Free Exercise Clause as well, where Justice Scalia helped overturn a compelling interest standard and replaced it with a rule in Employment Division of Oregon versus Smith. If one really, really likes rules and one really, really dislikes standards, one is more apt to find rules where others see standards. Interestingly enough, Justice Scalia did not completely abdicate judicial review over delegations in his Mistretta dissent. Instead, he applied a different non-delegation principle. The rule that Justice Scalia found in the Constitution was a bar on naked delegations of legislative power. More precisely, Congress could not create an agency that could do no more than create rules because Scalia claimed that the Constitution dictated that Congress could only delegate rulemaking authority to executive or judicial bodies that actually exercise executive or judicial authority. In other words, Congress could delegate only to its institutional rivals. The Sentencing Commission, by contrast, exercised neither executive nor judicial authority. In effect, the Sentencing Commission was nothing more than a junior varsity Congress, as Scalia put it, and this creation, said Scalia, was forbidden. In announcing and applying this rule, Scalia had rulified the non-delegation principle and thereby tamed judicial discretion, but this was more creation than interpretation of the Constitution. Justice Scalia cited no doctrine or history that supported his claim that naked grants of lawmaking authority were unconstitutional. And in fact, there are reasons for supposing that such delegations are less problematic than the conventional delegations that Justice Scalia accepts. Now on to Justice Thomas. Justice Thomas has repeatedly said that the court has been too lax in enforcing the principle that only Congress can exercise legislative power. His most recent discussion in DOT versus an American Association of Railroads evinces a willingness, one might say an eagerness, to strike down the capacious delegations that the court, since the New Deal, has repeatedly upheld. He candidly acknowledges that the non-delegation principle is a matter of degree, but claims that judges must enforce this principle because the Constitution establishes it. He refers to the enforcement of the non-delegation principle as a matter of judicial duty and characterizes the intelligible principle test as improper judicial abdication of that duty. But Thomas's position has messy nuance. First, he believes that Congress can delegate more in areas like foreign affairs, so he doesn't want to disturb Curtis Wright. Second, he seems to believe that Congress can delegate authority over public rights, but not private rights, relying upon work by Philip Hamburger and my colleague Caleb Nelson. Finally, Justice Thomas understands that it is perhaps best to conceive of the separation of powers created by the Constitution as having some overlap in executive, judicial, and legislative functions, meaning that more than one branch may have authority over particular subject matters. To use his language, the vesting clauses do not establish wholly separate spheres of authority, making it difficult to sometimes determine whether something is a power that can be exercised by Congress alone. So I think the best way of explaining the differences between Scalia and Thomas on judicial enforcement of the non-delegation principle is that Scalia is extremely reluctant to enforce constitutional standards where existing doctrine counsels non-enforcement. Thomas, by contrast, has little compunction about enforcing constitutional standards where he supposes that the Constitution establishes a standard. Let me transition away from Scalia and Thomas and discuss unconventional delegations. A couple of years ago, my former colleague, Larry Alexander, and I wrote a paper called Delegation Really Running Riot. The paper explored the structure of conventional delegations of lawmaking authority, something that we believe the vast non-delegation literature had ignored. And the paper asked, what else might Congress delegate, given the structure of conventional delegations and the relative acceptance of their constitutionality? We argued that conventional delegations of legislative authority consisted of delegations of authority of each of the chambers of Congress, right? It's a conventional delegation of legislative authority to say the SEC is a delegation of the House's authority and the Senate's authority. And the way to conceive of them is non-exclusive licenses granted by those chambers to those entities. They're non-exclusive because Congress can continue to legislate, and they're clearly revocable as well. The Senate is delegating its role to some administrative lawmaker, as is the House. Hence, when Congress delegates rulemaking, it is granting a revocable, non-exclusive license to legislate. But that's not the only feature of delegations. Crucially, delegations of lawmaking authority to non-executive entities like independent agencies or the states also contain another component or feature, namely a negation of presidential veto authority. When Congress authorizes the FCC to write communication rules without any presentment of those rules to the president, the legislation negates the president's power to veto. Similarly, when Congress authorizes the state to make federal law in various ways, it derogates from the veto power. So if we're right, if when Congress, when it delegates legislative power, can convey both its own authority and simultaneously negate the president's, what else might Congress delegate and negate? Could Congress delegate the right to admit states to some administrative agency? Could Congress delegate the right to propose amendments to the Constitution, leaving ratification to the states? And then going further, why couldn't Congress delegate authority to make amendments to the Constitution itself? We argued that the authority to make delegation of the authority that makes delegation of legislation or legislative authority proper and permissible under the modern doctrine is the necessary and proper clause, and that this clause likely makes unconventional delegations permissible as well. More precisely, if one believes that each chamber can grant non-exclusive licenses to legislate to third parties and thereby delegate each chamber's powers and also negate presidential power, then the necessary and proper clause likewise authorizes delegations of other congressional authority and derogations of other constitutionally assigned roles. Hence, the same clause that seemingly authorizes conventional delegations of legislative power and negations of presidential veto authority also would seem to authorize a whole host of interesting delegations related to state admission, impeachment authority, amendment approval, and even amendment ratification. Given the legality of conventional delegations, Congress could delegate quite aggressively in other areas and fashion tremendous changes. And if complexity and the need for more lawmaking requires delegation of lawmaking authority, why wouldn't those factors equally demand legislation, or delegation rather, of other cameral and bicameral authorities? With respect to all such matters, Congress has limited time and expertise, and with respect to all such matters, Congress has the necessary and proper clause, which gives it authority to carry into execution all powers of the federal government, not just legislative powers. And with that provocative claim, I'll end.
Thank you. Colin.
Thank you. I also would like to thank Mike and Stanford for inviting me to join this august company. I was thinking about the fact that if we had one of those California earthquakes, we'd set back administrative law in the United States by at least a generation. It's a great pleasure to be here. I don't believe that the delegation doctrine is a key for those of us who would like to see the administrative state disciplined. I think that's sort of a snare and a delusion. Elihu Root, J.P. Morgan's lawyer, said in 1916 to the New York bar, the venerable delegation doctrine has practically left the field. So that was 100 years ago. I think there's endless fascination because it's the legitimating fiction to some extent. I think you see that in the change of the name from the non-delegation doctrine to the delegation doctrine. But I think the key problem, the central problem of the administrative state is not delegation, it's civil service. It's the nature of the institutions to which power is being delegated and their lack of democratic accountability. We've created a large number of agency lawmakers who, as a practical matter, have lifetime tenure and very little political responsibility. Now, I recognize that the conventional wisdom is that they somehow derive their legitimacy from the president, who is elected. But my thesis is that that fundamentally misunderstands the Constitution. The framers were not in favor of an elected monarch. They were very concerned about an elected monarch. And I believe that they carefully set up a system of staggered elections with the Senate, the House, the President, the judiciary, and even the Constitution itself representing the different views of people over time. The second problem with the notion that the administrative state is legitimized by the election of the president is that it assumes that presidents can control the administrative state. And as Professor Postel mentioned yesterday, I think that's very, very debatable. If you read Clark Clifford's wonderful book, Counsel to the President, from his experiences as White House counsel in the Truman administration, they literally discovered what agencies were doing when they read about it in the paper. I think the situation has improved somewhat since that time, and I think the Obama administration has probably done the best job of any administration in history in controlling the administrative state. But they, too, have been confronted with important decisions which were not coordinated. The White House didn't know anything about them. Most recently, when the Department of Commerce announced that it was going to allow exports of condensate. This was a major decision in energy markets, and it became clear that this had not been coordinated with the White House. So I think the real problem in terms of democratic legitimacy comes when the president and agencies agree on a policy, but the people and the Congress are opposed to it. And an example of that situation, I think, is climate change. Although I might personally favor action on climate change, depending on the poll, 2 to 20% of people think it's a serious problem. Most people are not in favor in the polls of taking major action on climate change. Congress has repeatedly refused to act, first with McCain-Lieberman, and then when Waxman-Markey passed the House with Democratic control, it was not brought to the floor of the Senate because Harry Reid recognized that it had no way of passing. A couple of years ago, I wrote an article, Why the United States Doesn't Have a Renewable Energy Policy, trying to explain that to Europeans. And one of the major principles in that article was the separation of powers. Well, they've found a way around that pesky separation of powers concept, and we now do have a national renewable energy policy. It's called the EPA Clean Power Plan that was proposed in June of 2014. What could better epitomize the independence and lack of democratic responsibility of the administrative state than Mitch McConnell, the majority leader of the Senate, fresh off victories in midterm elections that have given the Republicans control of both the House and the Senate, railing against EPA's Clean Power Plan by writing an op-ed in his hometown newspaper, utterly incapable of stopping this type of action from going forward. I was very grateful for Professor Postel's excellent exegesis yesterday of what the literature shows, and particularly the reference to Ann O'Connell's wonderful piece in the 2011 Northwestern Law Review about what she calls bureaucratic momentum. I think a better word for it, I think that's too gentle, I think a better word for it is agency autonomy. I think so much debate has gone into whether or not presidents or Congress or the courts have greater control over the administrative state, and not enough attention has gone into the problem of whether or not anyone who is politically responsible has control over the administrative state. One piece of information, one little factoid that may illustrate my perspective is that when I was appointed as general counsel of EPA in 1989 and confirmed by the Congress, there were 18 political appointees at EPA, 10 of whom were out in the regions. So there were 8 of us at headquarters trying to ride herd on a career staff of 18,000 people. Right? So very, very little ability. And we made many decisions that neither we nor the White House wanted. So I think bureaucratic momentum is a very polite term for the nature of the problem. There are very few people that have really focused on this aspect of the administrative state. One exception is my friend Philip Howard, who in his recent book, The Rule of Nobody, recognizes the importance of the autonomy of career agency officials. But regrettably, in my view, he proposes to deal with the problem through greater presidential control and ability to hire and fire. I believe that the president is not equal to the government and that the midterms count. We should have an administrative state that looks more like America. Today, I believe as a result of the decline, did you like that? That's the phrase that liberals use when they're criticizing Barack Obama for appointing too many white men, that we need a government that looks like America. But my solution would be to make SES, the Senior Executive Service, members of the Senior Executive Service serve for a term of 3 to 5 years, subject to reappointment by the President and confirmation by the Senate. For those of you who aren't familiar with the Senior Executive Service, it was created in 1978. It's described in Title V, Chapter 43. It's fewer than 8,000 people, of whom 7,000 are career officials. They're basically the captains and majors and colonels. They have very, very substantial discretion. And they are subject to some performance review, but it's by a performance review board, which consists of other members of the Senior Executive Service, with a theoretical appeal to the agency head, but that almost never happens. I conceive of retention as being somewhat like state judicial retention elections. And I think it would greatly affect the decisions that agencies make if the senior career officials anticipated that they might eventually be called to account for their decisions and that they were not as autonomous as they currently are. Now, lest any of you think I haven't thought about it, I do recognize that there are some little difficulties about this proposal in terms of the appointments clause. There is some language in the free enterprise versus PCAOB case that Peter Strauss discussed earlier. We would essentially have to move SES from being considered inferior officials to being officers of the United States. But I think that's actually quite doable. There's a whole series of cases. There is some language, I would call it loose language and dicta in Justice Roberts' opinion, that says an inferior official is anyone who is supervised by somebody who is appointed by the president. That obviously does not work. That's a completely invalid test, because the deputy, the number 2 in any agency, is supervised by the agency head. So all political appointees are subject to supervision by other political appointees. There's earlier language that talks in a much more functional way about the nature of people's duties, the nature of their discretion, and I believe that while there is an issue, I think we could eventually convince Justice Roberts that it makes more sense for there to be some political accountability in members of the Senior Executive Service. So Mark Tushnut asked a really good question yesterday, and probably several very good questions, but one that I noted in particular was, how do we get any of these reforms enacted? Well, I was a little worried that my proposal was going to be too extreme, but others were talking about going to a parliamentary system and all sorts of things. So I think this is modest by comparison. And I think it would increase the power of both the president and Congress to supervise the career bureaucracy. So maybe there is a shared interest in making sure that the people's elected representatives have greater control over the unelected experts in the bureaucracy. Let me close by telling you how we used to deal with this problem at EPA, and I think it illustrates the dysfunction of the present system. So if we had any really, really troublesome employees who we just couldn't get to go along with the program, we'd promote them and transfer them to the OECD in Paris, because they couldn't successfully claim that they had been they'd suffered an adverse personnel action if we promoted them and transferred them to Paris. The difficulty with that as a permanent solution for creating political accountability in the administrative state is there are only a limited number of liaison positions at the OECD in Paris.
Okay, thank you. And Michael?
We need a bigger international administrative state, evidently. I want to join my fellow panelists in thanking Michael and his colleagues here at Stanford and Stanford Law School in general for the kind invitation. And I want to pick up where Mila and Don left off, so the enforcement state and agency autonomy, and I want to add one more wrinkle to it, which is agency finance. That's a little removed from administrative law. I've never taught a case about it. I don't know whether there is one really, but how these agencies operate financially bears on how we think about constitutional constraints and delegation and administrative law, I think. I want to sort of put aside for present purposes so-called NAFIs, non-appropriated fund agencies. There are a bunch of them, like the U.S. Mint. The biggest one is the Federal Reserve. Put that aside. I also want to put aside sort of agency finance question about agencies that run actual programs through user fees and the like, so park concessions or mineral leases. What I want to focus on is two increasingly common practices: agency authority to tax or to collect revenue from public but non-appropriated funds, and de facto agency finance through enforcement proceeds, fines, settlements imposed on regulated industries. As I just said, both practices have increased quite substantially. I don't have any data for you. Chris Samuth and I are working on an inventory. Check in with us once we've done it. So for today, I'll just give you some examples of what these things look like and then turn to the legal questions that I think are at issue. Examples of agency taxation. The Public Accounting Company Oversight Board, created affectionately known as Peekaboo, under the Sarbanes-Oxley Act, that operates through taxation. There's a $9 billion or so program run by the Federal Communications Commission called the Universal Service Fee that may or may not be extended to internet providers. The pending regulations are somewhat ambiguous about that. And then there's the Consumer Financial Protection Bureau. That's a somewhat special case. It's financed through a transfer from the Federal Reserve's accounts to the CFPB of up to 10 or 13% of the Fed's operating budget. And then there are examples of things that are nominally agency fees, but if you look at the structure, the way they're arranged, the de facto taxes, the FDA's fees operate like that. Examples of agency finance through fines and settlements include all these headline-grabbing settlements with big financial institutions. Much of that is, how that is run depends on the enforcement machinery. Much of it, of course, runs through the criminal stuff, through the Department of Justice. There are other agencies, obviously, such as the SEC, the CFTC, that have their own civil enforcement agencies. The numbers here, the figures that these agencies have come to collect are very large, sometimes large enough to turn the agencies into profit centers for cash-strapped Congress. Technically, of course, these agencies cannot make themselves self-financing that way. As a rule, the funds have to be deposited in the U.S. Treasury, so the agencies can't eat what they kill. There are some exceptions to that, such as the CFPB has a so-called victims fund where it gets to deposit its enforcement proceeds, which it then doles out to various housing groups. But the general pattern is it has to be deposited in the U.S. Treasury with two caveats or two additional observations. First, under a congressional practice initially instituted under the Reagan, or pursuant to the Reagan administration's request, the fees and fines agencies collect are offset against their appropriations. So agencies that collect a lot of money help Congress to make the regulatory state look much smaller, fiscally speaking, than it actually is. And the second quirky thing about these practices is that a lot of this money that you see advertised in the settlements in the newspapers, $13 billion from JP Morgan, very little of that actually goes into the Treasury. For one thing, the proceeds are usually shared with state AGs. More importantly, all these financial settlements include elaborate agreements to allocate credit, extend mortgage relief, and the like. FDA and HHS settlements with healthcare firms have the same structure. These are massive off-budget regulatory programs of a kind that the agencies could never, ever implement on their own statutory authority. Now, jointly and separately, I think these practices, agency taxation and agency finance through settlements, raise a number of intriguing problems. As I said, just as I don't have any data, I don't have any theory about it, but I'll just sort of mention sort of three things that spring to mind, three sets of problems. The first, most obvious set, I think, is about delegation. I think part of the standard theory is that delegation of rulemaking and adjudicatory authority is okay by and large for various reasons, but among them is the fact that Congress can always backstop the agency permanently by budgetary means. Self-financing, I think, casts some doubt on that theory, at least as a practical matter. Is that a constitutional problem? I don't know. I don't think so. There's no problem under existing law with unappropriated funds or agency taxation per se, at least so long as the amounts remain limited and the purposes are somewhat circumscribed by Congress. That's the Skinner case. The problem, if you want to find one, I think, is that two constitutional rights, delegation of a regulatory and then tax authority, may still make a constitutional wrong. You can maybe infer that from the Free Enterprise Fund case, but only with some difficulty. In pending cases, that theory has been rejected. I think the fact is that the existing constitutional constraints here are extremely weak. And on top of it, the problem here is that the only delegation that's clearly out under the case law, as I understand it, is self-delegation, aggrandizement. But the point of delegating tax authority on top of regulatory authority is not to make these agencies yet more independent from the Congress, it's to protect them against a future Congress. And so agency tax authority makes delegation, or for that matter, removal protections in some ways less problematic. That at least was Justice Breyer's opinion in his Free Enterprise Fund dissent. It garnered 4 votes there and no reply that I could see from the majority. The second set of questions, which is sort of due process-ish, the standard theory, I think, holds that public enforcers behave very, very differently from private enforcers because they can't keep the proceeds and their enforcement levels are set by appropriations. Those models, I think, look increasingly divorced from reality. The current practice isn't exactly for-profit law enforcement, but we're slowly getting there. You can think about sort of due process constraints in that setting, and there are some, when the enforcers personally get to keep the money, or their offices at least, and that's clearly the motive. Some of these, there are some cases like that, but they don't cover the general arrangements that I've described, and so I think that's not a meaningful constraint. Excuse me, and then there's finally the choice between rulemaking and enforcement authority as a way of getting your way. Of course, as Mila mentioned, the rock bottom proposition, chainery, and all the rest of it is that choice is the agencies. The notion that agencies might strategically abuse that discretion is as old as the principle itself. In the 1970s, Roberta Carmel, herself a former SEC commissioner, wrote a wonderful book on the agency's practice of regulation by prosecution, so it's not exactly new. But I think, to quote a famous administrative lawyer, Cindy Lauper, money changes everything. It's one thing to manipulate the procedures, it's another thing to monetize legal uncertainty. And it's very, very hard to see what else could be driving the practices that have now taken hold at FDA and HHS and the CFPB, and even totally boring agencies like FERC. Even in the appointments, you can see this, to the commissions. These are no longer experts who have some industry backgrounds. They're gunslingers, trial lawyers with a badge, and they act the part. Let me close on 1 minute of what's driving this. I think the institutional and economic incentives that push in the direction of sort of self-financed and profit-making agencies are extremely potent. Everybody benefits from it, but presumably that's a constant, right? And it's hard to explain the delta with a constant. So what has made this more prevalent over the past years? And I think among the main suspects, and again, it's a working hypothesis, it's not a theory. But the working hypothesis is what Rick Pildes mentioned yesterday, or what the entire panel, the first panel yesterday, discussed, which is congressional incapacity. Here, I mean, Congress needs the money, wants the money, likes the money, but this goes deeper. The regulatory systems in which these practices, self-finance practices or enforcement profits have taken hold most are regulatory systems in which you're looking at gargantuan rents conferred by the administrative state. Financial regulation, HHS, the FDA. Right? You could sort of mow down the rents in one way or the other in the usual fashion. You could regulate them, or the firms, or you could deregulate them and expose them to competition, or you could tax them. But once you despair of Congress actually regulating, you see what you see now. So they start to claw back a chunk of the rents by means of enforcement. And they create off-budget regulatory and redistributive programs that they cannot get from Congress. And they delegate to Congress, or delegate to the agencies, so that a future Congress can't easily reverse what has happened here, not certainly without losing the money that comes along with it. Maybe that's unduly cynical a perspective, but it would explain a lot.
Thank you. So we've had a stimulating discussion of various aspects of the ancient delegation doctrine. And in a famous book, Kenneth Davis said that we should forget all about delegation. It's hopeless. You can't enforce it judicially. But let's think instead about safeguards rather than standards. And so if you think about the discussions today, we see a variety of safeguards, more or less effective, to deal with the problem of excessively broad delegations. Mila particularly talked about the APA types of constraints, such as notice and comment rulemaking, and how that, if evaded, is a serious issue. Others talked about the problem of civil servants not being sufficiently responsive, and others of failures of presidential control. So perhaps the panel, let's give everyone a chance to speak now, and talk about what's a useful substitute for judicial enforcement, or anything else that the panel would like to discuss.
Well, I would just say that I am an ameliorist, in Mike McConnell's terms, like Peter Strauss. I think that we really need to, when we are building extra constitutional institutions or institutions that are not specified in the Constitution, we need to use statutory provisions to try to capture some of the wisdom and spirit of the Constitution. This is basically Harold Koh's argument in the National Security Constitution. And I think we need to do that in administrative law. And I think one of the key principles, which Peter Strauss has talked about in his 1984 Columbia Law Review article, is separation of powers. And I think that the difficulty with the administrative state today is that, in my view, Congress has much too little influence over it. Now, I think that's a substantial change, and I was delighted that Professor Postel was here, because I was wondering how in 12 minutes I was going to deal with all the political science literature, the McNoll-gassed stuff about. But I think that was in a very different era. I think it's very important to recognize that this power of the purse is much less of an issue for agencies today than it was in the 70s and 80s, for some of the reasons that Michael referred to, but also other reasons. You know, the political science literature in that period really identified appropriations committee chairs as the key figures that would define agency behavior. And I had some examples of that when I was at EPA. There was a senator who threatened to cut $500 million a year from our budget until we put a lab on Long Island, and eventually we did. But it doesn't work that way anymore. The Senate hasn't passed a budget in 5 years. Appropriations chairs are not necessarily even really consulted today. These continuing resolutions are being written in the leader's office or the majority leader's office, and one of the things that makes our government so fascinating is it keeps changing, and the way it worked 20 years ago is just not the way it works today.
Others?
So I'm going to say just two things. One is actually, I'm going to kind of ignore Professor Davis's injunction and suggest some limits to the ameliorist view. And the other thing is I'd like to talk a little bit about administrative procedure and sort of who has the incentive to promote the adoption of strong administrative procedures. So just on the first thing, I also am an ameliorist, but I also think it's very important to recall that there are limits to that portrayal of things. There are going to be points at which many people will agree that delegation does run out. And I actually was going to ask Sai here whether he thought that there were limits to delegation that could be found in Article 3 that perhaps were supplemental to and separate from the limits to delegation that you might find in Articles 1 and 2. So, for instance, we may have come to be comfortable with the delegation of lawmaking power as these delegations are conventionally done. But would we still be comfortable, for example, with a delegation to an agency to set the jurisdiction of the federal courts, or strip the jurisdiction from the federal courts? Or, for example, would we be comfortable with a delegation to an agency to promulgate state or federal rules of procedure or practice? And I've written separately about some reasons to be uncomfortable with the delegations of the power to set rules of evidentiary privilege. Just because it's a favorite topic of mine, I just wanted to point out that even if Article 1 and Article 2 obstacles to generous delegations don't seem sizable, there may still be looming out there some pretty rigid Article 3 obstacles to delegation. And then the other question, or the other point I wanted to ask is, it has to do with administrative procedure, and who in this, whether currently, given the configuration of politics in Congress, there really is any incentive out there to adopt a strong and robust set of administrative procedures, or to ensure that administrative procedure is robust. It may be that after the New Deal and after World War II, there was kind of an exogenous shock to the system that required everybody to sit down and come up with the APA and with rules of administrative procedure that would bind and constrain and legitimate the newly emergent administrative state. Now it seems that Congress may be willing to, rather than set up stringent rules of the road, sort of sit on its hands and watch the road and set up a checkpoint as and when it sees who's coming down that road. So Congress would rather, instead of creating strong administrative procedural rules, would rather have oversight hearings and adjust its appropriations and tether its level of oversight to the political identity and policy goals of the person down the street in the White House, rather than adopt in a blanket fashion strong rules of administrative procedure that would apply equally to any to a person of any political affiliation in the White House. And I'm sure Professor Postel and others will have much to say about the political science behind that.
Well, I'd like to respond. Go ahead, Mike.
Yeah. Just to sort of add something to this. The two mechanisms that everybody has in mind is Congress or the courts as sort of a check on this. If you're betting on Congress, you're betting on your ability to make Congress perform an unnatural act, which is to legislate. Once you're down that road, you ask yourself, well, what about the courts? What about the courts? I think the pattern overall, and I don't know whether this makes me a meliorist like, most people in this room, or a radical, I don't know. But you look at the general run of cases, increasingly, you see a lot of language to the effect that this has gone far enough. We're very concerned about the administrative state, which is taking over the world. And, Chief Justice says that sometimes, and sometimes it's Justice Thomas. Justice Scalia has chimed in on that note, but nothing happens. They're not willing to do anything that is actually a serious constraint on anybody because they don't think they can sustain this. And so maybe, and now I'm just free associating and speculating, maybe what you want to do is have a case that actually sends a signal. And that is, by that I don't mean yet another tirade against the administrative state. I mean, pick one case, one of these dogs from 70 years ago, and just overrule it and see where you end up. And the case where, one candidate I would have, I don't know, I was very impressed with Peter's insistence on, or emphasis on, look, there's a connection between the delegation and reviewability. And if you look at one case that sort of cancels that out, Yonkers versus United States. Right, because first it's this gargantuan delegation to the Office of Price Administration, and at the tail end they, rejigger or adjust the reviewability provision so that there is no review, there can be none. Maybe that, I don't know, maybe somebody else has a better case to overrule, but that's where I would start. Just to send a signal and then see how things shake out. I don't know what to do anymore.
Well, I don't think delegation is completely irrelevant. I didn't mean to say that, but I do think it's overrepresented in the thinking of lawyers about how we. I was thinking of people like my former student Gary Larson or David Schoenbrod. There are many people who harbor the, I think, unrealistic expectation that the courts are going to somehow dial back on the existence of federal government power through the delegation doctrine. And as Peter pointed out yesterday, the government keeps growing because people want it. And I do agree with Peter that this is contemplated under the necessary and proper clause. So I just think it's unrealistic to think that the delegation doctrine can be the primary tool. And if there ever was a case in which Yackas might have been overruled, it was Whitman versus American Trucking. And instead of overruling Yackas, Justice Scalia cites it as controlling authority.
I know.
It's hard for me to imagine a more conservative court in the United States. And so my reaction to Whitman versus American Trucking is sort of et tu brute. If you can't get Justice Scalia to enforce the delegation doctrine in a situation where how clean is delegated to EPA and billions of dollars hang on that decision, it's hard for me to imagine the realistic case that you're talking about, Michael, in which something gets overruled. On the other hand, with regard to Congress, it actually is a myth that Congress doesn't legislate. If you actually look at the volume of legislation, it's pretty constant. And I've done this in an article in NYU Environmental Law Review in 2008. It just legislates in different areas. It tends to legislate in areas where there's a perceived crisis. But there was tremendous amount of legislation about terrorism, tremendous amount of legislation about the financial crisis, and now about Obamacare. I think the difficulty is that there is a limited capacity of Congress to provide political decisions. And that's one of the reasons that we've developed these ancillary institutions to make political decisions. But my argument is, if they're going to be making political decisions, they ought to be more politically responsive.
Sai, a lot of this discussion really is directed at you.
Well, I guess I'm a little more radical than my colleagues and less of a amelioratist. But I thought there were some interesting points that I wanted to echo. I took political science from David Brady, and we learned about Speaker Czar Reed before there was Harry Reid. So there have been other times when leadership has really controlled chambers. I don't know if there was a similar decline in productivity. In talking about whether Congress can legislate, I have this anecdote in my mind about the National Defense Authorization Act and the constraint on transferring prisoners from Guantanamo enacted every year since Obama has been president. That suggests to me that if people, the majority party, and even whatever the majority party is, want to do something, they can do it. It's not impossible, even if they're using CRs to fund the government. And so I don't really know why it's the case that, given I know they have these sort of permanent funding mechanisms for various agencies. I don't see why Congress can't stop that when they pass the CR, right? They just attach a provision to the CR which says, notwithstanding whatever provision grants permanent funding, it's no longer available. There just has to be a will to do it. As for Mila's point about Article 3, I think it's an interesting thought experiment why we have so much support for delegation today amongst liberals. And I think the answer is because they like the products of expansive government. But imagine if Republicans created a deregulation agency which went around preempting state law without any standards, would just do good stuff. Go out and do good stuff under the Commerce Clause. I think many more people would find it plausible that there ought to be judicial enforcement of the non-delegation doctrine. And as to a specific legal point, if you believe that delegations of legislative authority negate the president's veto, i.e. take it out of his hand with respect to delegations to independent agencies, I don't know what it is about the veto that makes it negatable, but not whatever Article 3 provision she's talking about. So I understand that some people are, they really like the courts and they don't want exceptions made to their authority. That's fine. I understand the policy motivation, but either you believe that Congress can delegate its legislative authorities or you don't. And I don't know how one distinguishes, the exceptions clause of Article 3 from all the stuff in Article 1.
I wanted to pick up on one point which Sai made that I think was very important, and that is, Landis always talked about administrative agencies as being ways that politics and expertise could enter the system. And he used the term politics and expertise as if it were a compound noun, not recognizing that in many instances they really do pull in different directions. And I think a lot of people like delegation, and they like the independence and autonomy of the agencies because they are platonic guardians. They are paternalistic, and people perceive them as being wiser than the people. And so I think the challenge we've got is fundamentally, do we go in the direction of what is called in China and Singapore benign authoritarianism, in which we're governed by a group of experts who are not politically responsible, or do we think, with Thomas Jefferson, that wisdom really resides with the people? And I think I'm still with the people. I think there's a nice balance to be struck there. But ultimately, if the people are against it, I think we need a system in which it can't be crammed through against the will of the people. And right now, my perception is we do have a system in which it can be crammed through in many instances against the overwhelming will of the people. That's why I asked the question yesterday about what's good gridlock and what's bad gridlock. And the answer I was hearing was if there's a demand for the people from something, that's the discriminant. But I do think that many of the things that administrative agencies are doing are overtly paternalistic. And I think you see that in the writings of Cass Sunstein and Sarah Connolly, and many, many instances in which the executive branch explicitly thinks it knows better than the people and the elected representatives. Now, I think that's a real threat.
Well, I think we should give the audience a chance. I'll bet everybody has a question about this. If you don't, you've been asleep.
Everybody gets up.
So, someone sent me a link to John Oliver's last week's show on the IRS, in which John Koskinen said for every reduction of an IRS agent that Congress achieves, and there's been a 20% cut in the IRS budget over the last decade, that's $6 million of revenue the United States does not get. So I find it hard to agree that the power of the purse is less an issue today, albeit in the situations, I share Michael's concern with agencies that are free of the budgetary constraint, but where the budgetary constraint is there, it is really a constraint, and in some circumstances it costs us. I mean, the principal thing comment I want to make is for you, Mila. I want to leave the issues of waiver and case-by-case decision-making for this afternoon, but I suggest that you rethink the proposition that the guidance, the soft law side of things, is either new or out of the public view. 40 years ago, I was general counsel of an agency, the Nuclear Regulatory Commission, that had a body of regulations that on the shelf was about this thick, and a body of guidance documents that would have filled the screen behind you. This is a necessary and an ongoing element of any kind of technical regulation. And the point of the guidance is that it's not law, but it is helpful to people in knowing how they might be able to comply with regulations that, as we prefer, state what do you have to achieve and don't tell you exactly how you have to achieve it. There are issues about shouldn't there be more judicial control of that guidance, and I would tend to agree with you that the answer is yes, but not by forcing procedures that will drive the guidance underground, rather than by recognizing that in some instances the guidance creates high stakes, which should, in a declaratory judgment model, be regarded as having sufficient finality to warrant judicial review of their propriety. And the final thing in this regard I'll say is, and these things aren't secret, under the Electronic Freedom of Information Act, if not before, every one of them, if it is to have any influence on public context, must be in the agency's reading room. And that, in fact, has been one of the major advantages of the digital age for us, is in exposing to public view all of these documents. Go to the OSHA website and you find the manual of instructions to inspectors and whole ranges of guidance documents. It's not new.
Could I just briefly respond to the first of Peter's 3 or 4 points, and that is about the power of the purse? I certainly agree that where it's possible to get appropriations riders enacted into law, that they are effective. The reason that I said the problem I see is occurs when the president and the agency agree, but the Congress and people are opposed, is because of the veto. There have been times when riders were used somewhat effectively, but now in combination with CRs, with continuing resolutions, and the norm that has been established that it's the Republicans who are shutting down the government, it's very, very difficult for Congress to, quote, micromanage agency policy through the appropriations process. Where they can get something enacted into law, I agree with you, but with the veto, as a practical matter, if the agency and the president are aligned, they can make law, and it's very difficult for the Congress.
When did the president last veto a continuing resolution? And how many of them have got in them, hidden here and there, provisions that say, oh, don't spend any money on this rule?
Well, he doesn't have to veto them, but he does very effectively convey that if this is in it, he will veto it.
Can I?
Could I just,
Go ahead. Yes, Mila.
thank you. I just wanted to thank you, and I didn't mean to suggest, when I was using the word new, I was speaking in terms of decades, not years. So these, when I was, and you know, as Zach Price and others have written, these the waivers, which I primarily addressed today, have a long history extending far beyond the last couple of years. And so, I didn't at all mean to suggest that they were a very recent development. And of course, there are well understood costs and benefits to having these procedurally unfettered types of guidance issued by agencies.
Yes,
Two quick things. I'm very interested in this sort of question about the budgetary authority and sort of fiscal backstops. Presumably it's an empirical question. One could look at it, right? And I just don't know what the data would show. It's sort of one of the things one would like to do. Just one additional sort of observation, which is I'm sort of impressed at the huge variance from agency to agency. Right? So some have this completely sort of routinized procedure, and you know what you're getting. I don't think that that's actually true of the financial agencies. Right? There's all that sort of literature now about administrative law goes to Wall Street, or Gillian Metzger's latest piece. I think there's a great deal to that. I mean, you're talking about agencies, Treasury, the Fed, that are now undertaking sort of novel things that they haven't done in the past. They're operating under statute that have sort of mechanisms and funky things, including appointments by states to federal agencies that we haven't seen before, right? And so there's a lot to be worked out, and a lot of sort of the uncertainty about what's new with the administrative state, I think, arises in those fields of tension.
Michael?
A quick point and then a question. The quick point is that we just, Don, in support of your comment about the veto, we just saw this with immigration and DHS, where Congress would have liked to have an appropriations rider undoing DACA, but because it was going to be vetoed and the Republicans were going to be blamed for shutting down Department of Homeland Security, they couldn't do it. My question is really mostly to Mila and Don about just what to do. So, Mila, is it you identify a series of areas which you think have been expanding, where important policy judgments are not subjected to the traditional notice and comment rulemaking and so forth. Can this be solved by legislation that brings them within the ambit of that kind of procedural review, or do these things by their nature present questions or problems that can't be, I mean, like waivers, you know, who I think, you know, who has standing to challenge a waiver? Is it the person who's denied a waiver, or is it the person who's granted a waiver, of course, has no interest in challenging? And how can these sorts of things be brought within the ambit of a rule of law system? And I really have sort of the same question for Don, because your classic example, or your biggest example, is climate change, where you say, you know, the president and an agency can do what they want and Congress is out of it. I don't see how your proposal about the SES does anything to solve that problem, and I'm wondering what could be done to solve the problem.
Well, I think that example, it remains to be seen whether or not that's going to fly. There are significant problems with that in terms of the courts. I don't necessarily agree that my proposal wouldn't address it, but again, that's an empirical question about the dynamics within the agency. The agency has been wanting to do something like this for about 10 years, and they finally got the green light to do it. from the Obama administration. But I don't agree that if my proposal were enacted, it would have no effect on that. There was a way to do the Clean Power Plan that would have been less disruptive to some of the interests that are represented in Congress. Let me just leave it at that. Otherwise, we can talk about the details of the weeds of how you could have done that. And I think that more generally, you don't have to say that Congress has no power over administrative agencies, or that the power of the purse is completely meaningless to take the position that I do, that Congress doesn't have enough influence. I think the existence of, I always thought that CHATA and getting rid of the legislative veto was a terrible, terrible mistake, both constitutionally and as a matter of policy. And of course, Congress had the power of the purse at the time it was enacting 286 legislative vetoes. So it obviously felt that there was a need for more tools than simply the appropriations riders. So I don't want to be backed into the corner of saying appropriations riders are never effective. I don't think I have to do that.
So for on my question, on the question you addressed to me, I think that that courts in several of these contexts there may be cases withstanding, and courts may be able to judge the extent to which ordinary administrative law covers these exercises of power. That's not always going to be the case. So where are these additional procedures going to come from? So I hope you all correct me if I'm wrong, but I don't think that there's any obstacle to voluntary proceduralization by the executive. I mean, just to be more concrete, if the administration wanted to issue these waivers, using the full panoply of notice and comment, there's nothing to prevent them from doing so. So that suggests that the place where procedure might come from is public demand. If it's going to come from anywhere, it'll come from public demand for procedure.
Just a quick note on that. I think one of the biggest areas here is agencies using enforcement cases to really change the law. And I think if we really enforce the words of Bowen versus Georgetown Hospital, that we're not going to give deference to agency positions first enunciated in enforcement litigation, that would help a lot. And I think it would also help a lot if we beefed up the fair notice lines of cases. But very frequently, agencies, particularly EPA, are being very successful at changing the law through enforcement. And I think that's another way that illustrates, Mila's point about ways around the procedural system. Rather than rulemaking, they bring an enforcement case. It's a highly technical area. They're successful, and boom, a new rule is established. Peter?
So this is a great panel, and I'm feeling awful that my plane's going to require me to leave before the last panel, because Mila's paper already is making me think, I hope, more rigorously about my own position. I'm sure the last panel would do so. But I do have a quick question for you and a question for Don also, and that is, Peter Strauss and I were joking last night over dinner that what Congress really should be forced to do is, if we want to get rid of the enforcement state, or the discretionary enforcement state, then what the executive branch wants is for Congress to enact an unfunded mandates act that applies to the executive branch. I mean, right now, Congress's ambitions for what the executive branch can accomplish far outstrip the resources that they're providing, either because of just fiscal concerns, or because it's not bad, depending on your politics, to have a self-fulfilling prophecy of starving the beast and then criticizing the beast for underperforming. But in any event, a major issue with the proceduralization is that procedure also exhausts resources. And I'm afraid that the alternative to, and again, I'm not against substantive review of things like DACA and DAPA, but the alternative to the kind of discretionary state we're evolving to, if the push is going to be towards more proceduralization, I think we're just going to find less and more ad hoc decision making. So that's my question to you. Don, I'm just puzzled by your discussion of climate change is an example of the executive branch getting away from the people. Now, I know polls can be different, but this one was created at Stanford, so it's got to be right. This is from the New York Times in January. An overwhelming majority of the American public, including half of...
I rest my case. It's from the New York Times.
I'm sorry, it's Stanford. There's a link to Stanford University. And, you know, we want to restore civility here. Support government action to curb global warming, et cetera. This goes, they say 2/3 of Americans would be more likely to vote for political candidates who campaign on fighting climate change. I would have thought that the lack of legislation does not show that Congress is with the people. It shows Rick's point about the incapacity of Congress to legislate, even when a majority of the people have addressed the problem and have a pretty clear direction as to where they want to see the country move.
Well, I could have picked a different example. I picked that because it was an example where I actually agree with the action of taking action, and I thought it was an example of a situation in which, but you know, look, I don't think the example is very important. I think we could come up with a lot of other examples of where agencies are going forward with a policy that does not have majority support in the population. So I'll take your point that maybe that's not a good example of the phenomenon, but the phenomenon is nonetheless, you know, very, very, very real. That and I think in many instances, not only this administration but other administrations are able to pursue policies that do not have support in the Congress through administrative action, and that's the problem I'm trying to identify. Whether or not climate change is really one of them. I mean, I thought of it basically because of this wonderful, I think, exemplification of it in terms of, you know, Mitch McConnell's frustration. I mean, here's a guy who is the majority leader. They've just won these two elections, and he can't stop it, so he's writing newspaper op-eds urging states not to comply with it. To me, that exemplifies a situation which is very different than the kind of authority that major political figures had, I think, in the past. Certainly, John Dingell was very powerful at EPA 20 or 25 years ago, and I do think there's a change, but maybe it's not a good example. So I withdraw it.
It is.
So you said that, you know, the requirement to add procedures will cost money and may push agencies towards doing the same policies through ad hoc decision making. But the thing is ad hoc decision making itself costs money, and it might be cheaper to instead go through a route where you do notice and comment, adopt a rule that says you don't have to do a whole class of ad hoc decision making. You know, so it may just be that in the end, this is going to be an empirical question that's going to turn on a bunch of factors depending on the statutory context. But I'm a little skeptical of the claim that procedure is, that the costs of procedure are always going to mean that ad hoc decision making is chosen rather than the procedure and then the rule being chosen. But then at the end of the day, also, even if it does cost money, you know, good law costs money. You know, Hammurabi's code was very clear and very cheap to make, but it's not how we want rules to be made today.
So again, we want the Unfunded Mandates Act.
Rick?
I have a reaction that kind of links the last panel to this panel, and particularly kind of building on Mila's comments about this moment being a kind of New Deal moment for administrative law as opposed to constitutional law. But it's a little bit abstract. But you know, when Michelle was talking about the New Deal lawyers not just believing in this continuity story as a tactical or strategic matter, but actually, to the extent we can assess this, believing it internally, to me it shows a kind of, you know, formalism or legal formalism that's still infecting the New Deal lawyers, in the sense that, you know, what this involves in her story is abstracting legal categories like emergency, disaster relief into, you know, massive transformation of the regulation of the economy because of an inability to recognize distinctions between short-term emergencies and kind of profound transformations of the regulatory framework for the economy. And so to Mila's comments, I thought this was a way of characterizing your comments, that the phenomenon of waivers and at least some of the things you're talking about, where exceptions swallow up rules, the formalism is that law can't figure out kind of how to define a boundary between those two. Right? You know, we're doing the same things, and yet we're tremendously transforming the role of the administrative state. And I actually think that, I mean, seeing it this way now, and I agree with Peter, your comments made me rethink Peter Shane's comments yesterday about the immigration orders, or DACA and DAPA. I think this court actually thinks everything's justiciable, fundamentally, and that even though you can't draw kind of formal analytical lines on what these boundaries are, there aren't necessary and sufficient conditions of, you know, when the exception swallows the rule and the like. When you see the large phenomenon you're describing in the way you do, and I think, you know, people like Justice Kennedy are going to kind of intuitively have some sense of that as well. I mean, it makes it more compelling to me to think that there are justices who are going to think, well, we have to draw boundaries somewhere, even though we can't really give you sort of legal criteria that, you know, precisely define where that line is. So, I mean, it doesn't really require reaction, but it's just an observation about the two panels.
Yeah, thank you, Rick. My reaction is only just that at some point, you know, Justice Kennedy, who elsewhere has expressed skepticism and sadness about how there's too much law, is going to have to cope with the fact that he may think there's too much law but too little procedure.
Yeah, I don't know if the procedural out, I mean, I think it's really the underlying substantive issues, and I do have some concerns about the impulse to run away from the substantive tension that's here through a kind of procedural intermediation kind of escape that, but it's another comment.
Yeah, I'd make some comments on my experience with administrative law. Expertise in the administrative agencies.
Speak up a little more, please.
If there's any expertise in administrative agencies, technical expertise, it atrophies. When people have been in EPA for 20 years, they don't know how to do anything technical themselves. A ride between Dulles and downtown DC shows where the brains of the administrative agencies are. It's all in these Beltway bandit contractors. There is a very large body of standard-setting organizations. I've been in one for 25 years. OSHA once tried to take over our territory. We persuaded them not to. There is no reason for an OSHA at the federal level. Many of these things could be set by these standard-setting bodies and the state agencies. That's all.
Thank you.
So I wanted to pick up on some of Judge McConnell's comments and Professor Elliott's comments. I'm less concerned with the delegation doctrine.
Speak up a little more, please.
I'm less concerned with the delegation doctrine than the flip side of that, which is what I would call the arrogation doctrine, where the executive arrogates legislative power to itself through its actions and then dares Congress to try to do anything about it, knowing that it has the veto power and knowing that it will then argue to the Supreme Court that there is no standing. So some examples of that sort of came to my mind were the FCC's recent action regarding regulating the internet, where Congress may well come back and say, you can't do that, and then you get a veto of that saying, oh, yes, I can, because I just vetoed your saying that I can't. And then would Congress have congressional standing to then take that case up to the Supreme Court? Another example is the area of executive agreements in international relations dealing with China and greenhouse gas emissions, where, you know, Article 2, Section 2 says that Congress, the Senate, by 2/3 vote has to ratify treaties. So now you have this notion of executive agreements where the president is saying, well, it's not a treaty, it's an executive agreement. And if the Senate were to say, by a majority vote, you can't do that, again, you will get the president saying, oh, yes, I can, and I'm going to veto that. The Iran situation is similar, where the president enters into an executive agreement that isn't technically binding as a treaty and then dares Congress to try to do anything about it. So I wanted to get some comments on that.
Well, I think this is a very important point. I think what you're pointing out is that there is a big first mover advantage, and by creating a fait accompli and then saying to the Congress, you develop a veto-proof majority to overturn it, that really does change the decision rule quite substantially. I think one of the lines I took out from this SES proposal is that the most effective kind of power is power that doesn't actually have to be used to be effective. So I think the existence of a review process in which people would have to be subject to retention, in which the Congress played a role, would change the kinds of proposals we get in the first instance. But that isn't to say that if people make these proposals, you can't come up with an appropriations rider, if you can get a majority in both houses and a veto-proof majority. So I think you make a really good point of clarification, and I adopt it. I think you got a very good point there.
Can I speak to this sort of notion that you need a veto-proof majority to do something because the public will blame the Republicans? I mean, I view the Republicans as having basically told the public we want to shut down the government, and so whenever it happens, they're blamed for it. But if the Democrats control Congress and you have a Republican president, I don't doubt that the Democrats will try to negotiate with the president, because this is a negotiation situation. It's not as if only one party is to blame if the negotiation breaks down. They're both to blame, I suppose, in some measure. So I just wonder if this problem is just a temporary one, and if people, in Congress no longer say they want to shut the government down, but try to blame the president, if that in fact happens, whether in fact we go back to a different situation where one side is able to say to the president, you need us, we need you, let's negotiate now, as opposed to saying, we want to shut the government down. I think that was that's the reason why the people blame the Republicans, because the Republicans have said that's what they want to do.
Zach?
So I enjoyed the discussion very much, and this is really more an observation than a question, but I thought I'd throw it out and get your reaction. It seems to me, listening to you all, that there are two different lenses through which we can look at a lot of the issues you're raising. One is that Congress has the sort of legislative heart of the government, and our legislative process is famously hard with lots of veto points. So when Congress passes a law, we want that to take effect. And then from that perspective, one thing that Congress does is it creates a mission-driven agency that ensures that the policy is going to carry forward through future administrations, and this political moment in which it's able to achieve something isn't lost. And so from that perspective, the threat is that the executive branch will come in and not respect the legal mandate that Congress has imposed and sort of undermine that structure. Sort of second perspective, a second lens, is that this is all a sort of runaway dead hand of Congress's past, and what we really need is for a heroic president to come in and sort of slash through the red tape and effectuate the people's will. And I think one of the interesting things that's happened with the Obama administration is that in the past this had a pretty straightforward left-right valence, that it was people who favored regulation or sort of pro-Congress, wanted the executive branch in a box so that these mandates would carry forward. But now what we see in this administration is that it turns out that there's some legal debris that Democrats would like to clear away too, and so they encounter the difficulty of taking away law through that difficult legislative process. And it seems to me that as a matter of legal and constitutional interpretation, we really should be aspiring to some kind of trans-substantive perspective on these issues. And but I'm wondering if there's any way to do that, or if we sort of just always end up back with our kind of policy priors on whatever issue we're talking about.
Well, let me relate that to Sai's comment. I think it will be very interesting to see whether or not these problems really are structural, or they are just an artifact of a particular political configuration at a particular point in time. My colleagues who have served in the legislative branch tell me that they really think they're structural, and that people really don't talk anymore, they don't compromise anymore, and that there are a lot of institutional factors that account for that, some of which were. So I hope you're right in a way, but I don't think you are. I think these problems are really going to be structural, but I think we'll see when we get a little different political configuration. But I do think that the kind of difficulties we have in compromising in Washington today are not going to go away, and that means, who's got the first mover advantage makes a really big difference.
Just sort of add maybe one sort of wrinkle to this, which is, this goes back to something Rick alluded to yesterday on the first panel, and that is sort of the pressures on the administrative law doctrines. The way this looks like to me frequently, especially if you have to teach it, is the entire administrative law enterprise screams FDR, right? It presupposes that, it says the will of the Congress must prevail. That is the rock bottom presumption of the entire enterprise. That's easy to say, that's easy to think if your sort of vision of what Congress ought to look like or looks like is 1936. And if Don is right, or Don's colleagues are right, or the perceptions are right, that things have sort of structurally changed, that becomes very, very hard to sustain a body of administrative law that rests on that. And I think even if it weren't the fact that Congress seems as incapacitated or is as incapacitated as it seems or whatever, even if you had a somewhat more functioning Congress, you'd still have that problem, I think, under modern day circumstances, that the administrative law doctrines that we once thought were adequate to sort of managing this beast would no longer suffice.
Well, I'd like to ask the panel what they think about the nuclear option for dealing with this problem. And that's the RAINS Act, which is about to be enacted by passed by the House of Representatives. Now, Obama's going to definitely veto it, but it's still going to be around. A Republican president might sign it. And under the key provision of the RAINS Act, no regulation of economically significant reg can become effective unless it's passed by a joint resolution of Congress and then signed by the president, as required by a joint resolution. That would change the regulatory state in unimaginable ways. So people concerned about delegation, do you want to go that far?
Well, I think that's a good idea. I think otherwise you could just sunset regulations, right, and require that the agency not reenact them and have them go to Congress. I am troubled by the fact that the Constitution contemplates 3 branches, and in fact we have a 4th branch that does all 3 things. And so I would support that, and I understand the end result is that perhaps we have fewer regulations. But I think that's the price of our constitutional system.
Yeah, I would also support it. I think it works pretty well from what I can tell in the European Union. That's basically the European Union system in which the experts have a monopoly on the initiative. They write things and then they go to the Parliament to be enacted. It is, I think, a deviation from our historical traditions, as Peter pointed out. But I think that if we can't develop some other mechanism of having compromises and negotiations between the executive and congressional branches, I think that's exactly what's going to happen, is that when you do at some point get a Republican majority in both houses and the presidency, which will happen at some point, that will probably be enacted, and then it will be on the books, and it will be up to the question of can it be repealed. I'm not sure it would reduce the extent to which we have regulations. We might have to have a different definition of what constitutes major. But I think that Congress's capacity to get into the details is really very, very limited. So I think that they would really focus on relatively few but highly significant regulations. And there'd be a lot of negotiation in advance. So I don't think it's a bad idea.
Well, good or bad idea, it is time for lunch. So thank you, panel.